car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending your Sunday evening with us. Our topic of conversation, wills and estates, making sure that you're taken care of and your family is, your money, your property, all of that is long after you're no longer with us. Interesting half hour we've got planned for you. Would love to have you be a part of it. You'll see ways that you can join the conversation. You can call, text, email. Also a reminder that something that the firm of Hollis Wright always provides while the attorneys is on the air is there's an attorney standing by right now to speak with you. So your opportunity to get some great free legal advice, and urge you to take advantage of that. Leading our conversation from the firm of Hollis Wright, Carter Clay. How are you, sir?
I'm doing fine. I hope you're doing well.
I am, thank you.
Yeah, wills, estates, trust, we're going to be talking about all of those legal documents, and I know sometimes we often start out by saying that the topic we're covering is pertinent and relevant to the viewers out there, but I can guarantee the viewers this is a topic that is relevant and pertinent to everybody unless they figured out a way not to die. Right. Because everybody is going to pass away at some point. They're going to have family members and friends that pass away, and what to do with the deceased estate, the assets that they leave behind, is really what we're going to be addressing here tonight, and really how to make the process easier on the family members, which from my standpoint would be very important to me when I pass away, to know that I've got everything in order so that my widow and my children don't have to deal with it, or have to deal with as little as possible. Right now, statistics show that about 55% of the adults out there do not have a will. And that percentage is even higher when you look at racial minorities, African Americans, Hispanics, and those types of classes of people, that the statistics are about 65 to 75% of those individuals don't have wills if they're an adult. And so obviously, again, this topic is pertinent to all the viewers out there, especially to those individuals who don't have their house in order already. We're very fortunate tonight to have Tim McCool with us. Tim is an outstanding young attorney in the Pickens County area and practices in Pickens County, Fayette County, and Lamar County as well. That's primarily where he focuses his practice. I think he's got a general practice, but focuses somewhat heavily in the area that we're here talking about tonight. So he is very qualified and informed on this particular topic. So Tim, thank you so much for being here. We look forward to having you.
Glad to be here. Appreciate it.
Tell us a little bit about your legal practice, and in particular your focus on wills and estates and trust and those types of legal documents.
Well, to some, my practice in general might be sort of like a relic because we do a little bit of everything. Kind of a throwback from years gone by when there wasn't so much specialization, but we do a little bit of everything, and a primary part of what we do is wills and estates and probate work. As a matter of fact, it's over the last few years especially, it has been a larger and growing part of what we do on a regular basis. I am in a firm by myself. The firm has been there since 1905. A lawyer has been in that firm, and so I'm the most recent one. And so we do a little bit of everything, Pickens, Lamar, Fayette, but we do a lot of work on simple estate planning, and I found that it is so very important. Folks can get into spending so much money that they didn't have to spend if they'll just do a little bit of estate planning.
Well, and one of the things that I like to start out with this type of show is to explain to the viewers that if you don't create your own will, the state has a will for you, and you may not know it, but the state will dictate where your assets go upon your death. Is that correct?
That's correct. It's called intestate succession, and basically what it means is that if you don't say what you want your things to go to or who you want them to go to, then there is a law in the state that provides where that will go. Now, a lot of folks think, well, if I don't have a will, it's going to automatically go to the state of Alabama, but that is not correct. Now, there is a situation where that could happen if there are no heirs, but with intestate succession, your property might still go to your wife or your children, depending on what you have, wife or children or a spouse, but it makes it a lot easier whenever you have a will, and there's a few hoops that you have to jump through on intestate succession that can be something that you don't have to normally do.
Right, and I think it's important to understand too that how the state dictates where your assets go, they're varying ways of distribution in terms of what the state is going to dictate, but the problem is you may not want your assets to be distributed how the state will distribute those assets, and so having that control, creating that will, that legal document that's enforceable is very important.
Absolutely, you're correct.
Talk to us about estate planning and actually what does it involve? If I'm watching right now and I know that I haven't done any estate planning, kind of walk me through what that looks like.
Well, it's kind of hard to put any more emphasis on one or more documents that we do. I have a hard time prioritizing those documents because they all really have an equal importance.
Right.
But obviously, we're talking about probate, and that involves the will, the last will and testament of someone. We do simple wills, 3 or 4 page documents, unless someone wants to get very detailed with different items and things that they have. But if someone came in, as they regularly do, and said, I want to do some estate planning, I would make 4 recommendations to them based on the size of their estate. And those 4 recommendations would be to have a last will and testament and to have a general power of attorney. And also nowadays, because of various medical rules and HIPAA and such, I would wholeheartedly recommend a medical power of attorney. And then also I would recommend a living will, which has to do with what I refer to as a person's instructions on right to die whenever they are in a bad situation that's clearly defined by the document.
Right.
So those 4 things are of paramount importance when it comes to planning a person's estate.
And let's talk about those 4 documents that you place importance on, and in particular we'll talk about with the last will and testament first. What criteria does an individual have to satisfy in order to create a will that is legally enforceable upon death?
Well, it's very simple. Basically, for the execution of a will, which just means making the will valid, they just have to have a signature there with 2 witnesses and a notary. We are in a state now, several years ago, they passed a law where we are a self-proving will state, which means you have 2 witnesses and a notary to the signature of the individual. Now, I've always pointed out that the people that witness and notarize the will do not have to know what's in the will. So it can be any individual that witnesses a will, but they're just witnessing the signature. And so it's very simple in executing a will. It's actually easier than it used to be because you have the 2 witnesses and a notary. As far as what a person wants, they just come in and we take down information about what they have and specific items that they may want to go here or there, monies, accounts, investments, and things like that, and just put it in the form of a will and have it executed after a few days of preparation.
Can an individual distribute their assets 100% like they want, or are there protections in place that protect a spouse from getting squeezed out?
Well, in general, they can leave things like they want to. There are some provisions in the law that might override and could override certain situations where someone might be trying to intentionally cut someone out. So there are some restrictions, some limited restrictions regarding where you can place your assets.
Let's step aside right there. Let's pause there. We're going to take our first break of the evening. As we do so, a reminder of how you can join our conversation. Call, text, email, get in touch with us here. Would love to hear from you here. More of the attorneys on the way. Stay with us.
I'm Carter Clay with the law firm of Hollis, Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
those important questions we need to be asking ourselves, talking about wills and estates. Welcome back in to the attorneys. Carter?
Yeah, Tim, I don't practice in this particular area, but handling personal injury, civil litigation matters from time to time. We represent individuals who have passed away in an accident, and we have to ask them, did you have a will, or did the deceased have a will? And they say, well, yes, but we can't find it right now.
Right.
And so what would you recommend, or what do you tell your clients after the will is completed? Do you keep a copy? What do you recommend that they do in that regard to make sure they can find it?
Right. Well, across the board, I recommend that they take the original will and put it in a safe place. Maybe a safety deposit box or a fireproof safe at home. That is always a good place to put it. I do not keep any originals because that would be a tremendous source of liability, especially if someone changed a will down the road and I still had an original. So we send the original out with the client, and they put it in a safety deposit box or a lock box that is fireproof. And I always instruct them to make sure they let their relatives know, especially the one that is the executor in the will or the alternate executor who will handle the probate when the person passes away. I always make sure that they let some relatives know where it is. And I might also point out, if you have a safety deposit box, it's very important that someone alive has access to that safety deposit box and authority to access it, because if the one who owns the box passes and the will is in there, you have to get a court order many times to get into the safety deposit box, which can be a nightmare. So just want to make those kind of plans ahead so that the will can be accessed.
Sure. You mentioned changing a will in your response. Can a will be changed, and how does an individual go about doing that if circumstances dictate to them they should change it?
Yeah, I have a client that I've changed wills for him many, many times. He's just a perennial will changer. And what I have him do is bring in the last original, and after he executes the new will, then we will tear up the old one and just throw it away. So there's no restriction on how many wills you can make. You just always want to dispose of the previous original so it won't be laying around somewhere. And there's a clause in the wills that always say, by this current will, I am revoking any former will. But just to be extra careful, we always destroy the previous will and the new one takes the place of it.
Mm-hmm. What advice do you have to those viewers out there that may be thinking, I just don't have that much, it's going to be too expensive to hire a lawyer to draft a will? What are the expenses involved in getting a will done?
It's not that expensive. As a matter of fact, I've often said that a stitch in time saves nine. A little fee spent here can save a lot of trouble down the road. For a simple will, $150. For reciprocal wills between husbands and wives, we usually charge $150 a piece and give a discount for a husband and wife because they're basically mirror one another. Mm-hmm. So you're talking about a $150 document that can save you a lot of trouble down the road that would cost a lot more expense than that.
Yeah.
And generally, just walk us through the process of probating a will. A loved one passes away, family member has the will. What should they do at that point?
Well, a lot of times people think that once they execute the will, that's the end of it. But that's not the case. The will is valid whenever it's executed. It is a valid will, but a will does not have legal impact or authority until the person passes. So what happens is they pass away, and then the will is brought into an attorney to file the will for probate, and it has to be the original will. A moment ago we were talking about if a will gets lost or if there's one misplaced, that can become a problem. A copy of a will can be probated, but you have to go through more hoops and more steps to actually get that probated. I've even seen where a blank will has been probated occasionally based on testimony of those that were near to the person who passed away. So you take the original will and it come into an attorney, and they file a petition in the probate court, and then it just goes from there. There's some time frames that have to kick in, and there's also publishing it in the paper that the will is being probated, and that is when the will has the legal authority to distribute the things that the person has distributed in their will.
Well, what about a question here about minor children? what can you do to protect your minor children?
Well, in a will, it's a very simple matter of putting in the will a provision to take care of a minor child. You can do a guardianship clause in the will, and you can also do a trust clause in the will. For example, if someone left monies or even insurance monies with their children as beneficiaries, they could leave those monies to a trust that's created in the will when the person passes. And then a lot of times the guardian and the trustee can be the same person, but they don't have to be the same person. So you can provide in the will based on a guardianship clause or a trust provision for a minor child and include that in your will, which makes it a little longer and can cost a little bit more, but if you have minor children, it's worth it.
And Tim, the second document I think that you mentioned early on in the show after the last will and testament is a durable or a power of attorney. Explain the differences between powers of attorney and what they allow for.
Well, as we said, the power of attorney is one of those 4 documents that I across the board recommend. The difference is the will has to do with when the person passes away, but the power of attorney is in effect while the person is alive. And it has to do, the way I describe it, it has to do with making business decisions and paying bills and carrying on the business of the person as if they were that person. It's interesting that we should point out that executing a power of attorney in favor of another person does not mean that the person is giving up their rights. They are just simply authorizing someone else to help them. And with the older folks that I deal with on a regular basis, I say to them, if you're tired, if you're worn out, if you're just not feeling well, you could use that power of attorney to have someone who you've appointed to go and handle things that need to be handled.
And obviously they'd have to be a trustworthy individual, somebody that you have a great deal of confidence and faith in to handle it according to your wishes.
Absolutely.
Let's step aside for our final break right here. We've got one more segment of the attorneys coming up. As we step aside, a reminder that you can find the firm of Hollis Wright on Facebook and Twitter. Search that term, Hollis Wright on Facebook. You'll find them there. And on Twitter, it's Hollis_Wright. Stay tuned. The final segment of the attorneys coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Those firm facts with some helpful little tidbits. Welcome back to the final segment of the Attorneys. Just a few minutes remaining. If you have a question, go ahead and take advantage and get in touch with us. Carter?
Yeah, Tim, I've heard of individuals who want to take care of parents or other elderly family members, creating a guardianship or a conservatorship. Talk a little bit about what a guardianship and a conservatorship is, and does that accomplish the same thing that a durable power of attorney would accomplish, and what are the expenses involved in each of those?
I've had people come in and ask for a power of attorney before whose parent or the elderly person or even a younger person was incapacitated. And a person must have their mental faculties to be able to execute a power of attorney. The sad thing is sometimes a person will become incapacitated, and the only thing you can do at that point would be to set up a guardian conservatorship in the probate court, which can be and really is very expensive and time consuming. So if you have a power of attorney in place, it can save a lot of time and money, and it does basically, in essence, the same thing that you would do if you went into probate court and spent several $1,000s on an incapacitated person to set up a guardian conservatorship. So basically, if a person has their mental faculties and they are able to think for themselves, then it's a great idea to go ahead and have a power of attorney in place so you don't have to go to that type of trouble or expense.
Yeah, I think that's really a great example and really hits home the point of why you don't want to delay and procrastinate in doing the estate planning things, such as creating a will, creating powers of attorney, trust, living wills, medical directives, and those types of things. That's really a good example, because if you wait too long, and once they become incompetent and can't engage or enter into a power of attorney, then it's too late. You've got to go a different route, which can be very costly.
That's right.
Sometimes the terminology with you legal guys, it can just get confusing for us, us laymen, okay?
It's confusing for us as well.
Yes,
but
that's right.
Glad to hear that, because, and especially related to this. So help us understand the medical directives and the living wills. Those are the same things as different names for them, and define what they are.
Yes, sir. That's right. Living will is just another name for the advanced medical directive. And the way I try to distinguish that, obviously it says living will, which means it's while the person is still alive. So it is honoring their wishes while they are still alive. Now the living will or advanced directive for medical care has to do when a person gets in certain conditions. It might be being completely incapacitated due to an injury or because of some mental progressive dementia or something like that. Right. So the living will just says, when these circumstances arise, this is what I want to take place. Do I want to be kept alive for a extended period of time if there is no hope and no expectation based on doctors stating that there's no expectation of recovery? Some people want to and some people don't.
Right.
In my experience, most of the people that I've dealt with do not want to be kept alive in a situation like that when there is no hope of recovery.
Mm-hmm.
How is it handled if no living will exists and or there's no advanced medical directive and somebody gets in a tragic accident of some kind, let's say, and is in a vegetative state, can't communicate? Who makes the decision, and what hoops does the individual decision maker have to jump through?
Well, that's very difficult because what happens is the medical personnel make that decision. The doctor would normally make that decision. If there was nothing in place, he would just go based on what he felt like he needed to do. So it can become a bad situation when that is taken away from the family members to decide. And it also needs to be pointed out that in a living will, the actual person is deciding what they want in advance, so it doesn't put the pressure on family members to come in and say, oh my goodness, I don't know what we need to do. I don't know what mom or dad would want here. They have said in a document, this is what I want. And therefore, that is what the hospital, the doctor, and the personnel are bound to do.
Right, and one thing I think that's always good to point out in this show, David, is not every asset that an individual has is subject to a will and or subject to the probate process. For instance, a lot of individuals have life insurance out there, and life insurance is a contract between the insured and the insurance company to pay out life insurance benefits in the event that the insured or the individual that took out the contract passes away. And if they name a beneficiary, say they name their spouse as a beneficiary, contractually the spouse gets that money. It's an asset of that individual, but it's not really subject to the probate process because it is a contractual document. And there are other examples too, like a 401k, a retirement account, where a designated beneficiary is in the 401k plan. Those can pass outside of the estate because they're subject to contract laws and things like that. So I think that's always important for individuals to remember, and it kind of distinguishes those assets that are subject to a will and probate process versus those that are not.
Right. In terms of the documentation needed for estate planning, what do you need there?
Just basically the information about what the person wants to do.
Right.
If it's a husband and wife, usually the husband leaves everything to the wife leaves everything to the husband, and if one or more of them, either of them are deceased, then it would fall to the children.
Right.
That's usually just the information of what the person's preference is. Now, they can be as detailed as they want to be.
Right.
If they've got an item that they want to go to a specific person, relative or not, they can state that in the will, but it has to be stated.
Yeah.
Otherwise, it would just go in general to the ones that they leave it to.
Yeah, we just have a couple of minutes remaining, so time enough just from both of you all, kind of a final thought from you, and we'll let you go first.
One additional document that might be of interest, aside from those four that we've talked about, would be when someone owns property together, a husband and wife owns property together, they can put their property in a right of survivorship deed, which means that automatically upon the passing of one or the other, it passes to the other, and it doesn't have to go through the probate process, which is a good thing for them to not have to worry about their house or their property that they own.
Right.
So that's a good thing to keep in mind, an additional document that can come in handy.
Yeah, that's just another example of the life insurance, the 401k, where you can do things outside the probate or estate process. The thing I would emphasize is do your due diligence, prepare, help your children out, help your family members out. Don't wait until it's too late to engage in these estate planning process, because ultimately what will happen is it's going to fall on the children. They're grieving, they're obviously upset, they've lost a family member or a loved one. Allow them to grieve, focus on that, and not have to focus on all of these things that we've been talking about, because eventually the more preparation that you have, the more you put into it on the front end, the less likely it is that the family members or the heirs will squabble and fight.
Yeah, planning now prevents the pain later, for sure. Appreciate both of you being with us tonight. You as well. Thanks as always for joining us. We're so grateful that you join us each and every Sunday night. As we wrap things up, maybe you got a question you want to get into the firm of Hollis, Wright. Here's how you can do it. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.